Let's talk about two of the most powerful tools we have in healthcare for improving patient safety: clinical audits and peer reviews. The thing is, these tools, they come with a significant risk. If they're handled the wrong way, they can become a legal minefield. So in this explainer, we're going to break down exactly how to use them effectively while also shielding yourself and your institution from legal exposure. And that really is the core dilemma, isn't it? How do we build a culture where we can have honest assessments, where we can have continuous improvement, without also creating a paper trail that can be used against us in court? It's a critical balancing act. And, the stakes really couldn't be any higher.
So, to answer that question, here's our roadmap. First, we'll look at the quality risk dilemma. Then we'll dive into your legal shield, the concept of privilege. After that, we'll get practical and walk through structuring a safe audit, take a quick look at different legal jurisdictions, and finally, we'll talk about how all this helps build a true culture of safety.
Okay, first up, the quality risk dilemma. Let's make sure we're all on the same page about the tools we're using and, of course, the stakes involved.
First, it's really vital to be precise about our terms here. A clinical audit, that's all about focusing on systems and processes. It's data-driven, it's a structured cycle of improvement. A peer review, on the other hand, well, that's different. It evaluates an individual clinician's performance, and it's often triggered by a specific adverse event. Both are aiming for quality, absolutely, but their focus and their legal implications are worlds apart.
So how do we protect these absolutely essential processes? Well, that brings us to your legal shield, privilege. This is the core principle, the very foundation that makes safe, honest audits even possible. So what is peer review privilege exactly? You can think of it as a powerful legal doctrine that creates a confidential space. It essentially shields the documents, the discussions, and all the records of a quality assurance committee, preventing them from being discovered or used as evidence in a lawsuit. This protection really has two key parts. First, the materials are protected from discovery. What that means is an opposing lawyer in a lawsuit just can't demand to see them. Second, they cannot be used in litigation. You put those two together, and what you get is a legally safe space for the kind of candid, critical evaluation that's absolutely essential for real improvement. And if there's one rule to remember, it's this: segregation. It is the single most important thing you can do to maintain this protection. A patient's medical record is for their care, and it is always discoverable. An audit document, though, is created for quality improvement, and it's privileged, but, and this is the crucial part, only if it is created and stored completely separately. If you mix them, that privilege is gone. Okay, knowing the principle is one thing, but putting it into practice is something else entirely. So let's get practical. Section 3, structuring a safe audit. Think of this as your playbook for protection.
Here are 5 absolutely essential steps. 1. Clearly define the purpose as quality improvement, not pointing fingers. 2. Formalize the committee. Give it written terms of reference because informal chats don't get legal protection. 3. Rigorously, and I mean rigorously, segregate all your documents. 4. Use de-identified data whenever you possibly can. And 5, the committee's output should be recommendations for system improvement, not findings of blame.
The language you use in these documents is absolutely critical. The words you choose can either create a ton of legal risk or they can maintain that protection we've been talking about. So instead of assigning blame, something like Dr. X made a mistake, the report has to use objective systems-based language. For example, an opportunity was identified in the monitoring protocol. See the difference? This shifts the focus from an individual to the process, which, of course, is the whole point of a quality audit.
And because the stakes are so high, let's just quickly look at the common pitfalls that can completely destroy this protection. Unstructured criticism in emails, that can be discoverable. Your own audit notes can be misinterpreted as admissions of fault. And please, be warned, informal chats on platforms like WhatsApp, they create a discoverable legal record. A single careless message there has been used to undermine an entire quality review. And finally, never, ever copy audit findings into a patient's medical record.
Now, these principles, they don't exist in a vacuum. The legal protections for peer review vary quite a bit around the world, so let's broaden our view a little in Section 4 and talk about navigating different jurisdictions.
So in the United States, you'll generally find the strongest protections. And this is thanks to a combination of state-level peer review privilege laws and the Federal Patient Safety and Quality Improvement Act, or PSQIA. The framework there is really robust, as long as the rules are followed, of course.
Over in the UK, Canada, and Australia, a very similar principle applies. Statutory protections do exist, but they're typically tied to formally constituted quality assurance committees. The key word there is structure. You need an official, recognized committee for that legal privilege to kick in.
Now, the context in India is unique and it requires extreme care. Why? Because there's no explicit peer review privilege statute on the books. This means your internal discipline isn't just a best practice, it's your primary defense. While courts there do typically focus on the clinical record, it's absolutely paramount to maintain strict confidentiality protocols, and, this is huge, avoid any language in your audit documents that could be interpreted as an admission of negligence. In this situation, your process is your protection.
And all of this brings us to our final section, building a safety culture. This is really about moving beyond just mitigating risk and toward a proactive, continuous cycle of quality improvement. You see, when audits are run the right way, everybody benefits. For clinicians, it means reduced legal risk and a real framework for clear communication and learning. And, most importantly, for our patients, it leads directly to safer care and better outcomes. It's a true win-win. So how does an institution make this a reality? Well, you embed these best practices into its DNA. You train all committee members on confidentiality. You use standardized templates for every audit to ensure consistency. You have legal counsel review your committee structures. And you always remember the mantra, document improvements, not blame, and maintain that strict segregation of all audit files.
Let's end on this core idea. Great audits don't just find problems, they build a culture of safety. Because ultimately, the goal here isn't just about avoiding lawsuits. It's about creating a system that is so rigorous, so transparent, and so committed to learning that it consistently delivers the absolute highest quality of care. That is the true purpose, and that is why this matters so deeply.